Everyone, as promised, in addition to breakfast this morning, we have a very distinguished guest lecturer, my colleague, and one of the very best intellectual property lawyers you will ever have the pleasure of being in the same room with, and I mean that, Mike McGurk. Mike has done everything when it comes to intellectual property. He's, of course, he not only has a legal degree, but he also has an engineering degree. He's worked at the USPTO as a claims examiner. He's the guy that gives, thumbs up or thumbs down like the emperor to your inventions. And, of course, he's worked in the private sector for the very best intellectual property firm that there is. Fortunately, he has seen the light, and he's now off on his own so that we can do cases together. But there isn't anyone I would want to associate with more when it comes to intellectual property than Mike. And I've asked him, and he's kindly agreed to come in here and tell you a little bit about what he knows so that you can get a feel of what it's like in the real world out there. Think of this as having an opportunity to consult with an attorney without having to pay $750 an hour. All right. So with that, I want to introduce
a great introduction. Thanks. So I've been in the legal business since about 1986. I was in one firm for 28 years, the Finnegan firm, if anyone's heard of the Finnegan Group. Then I unwisely moved to a bigger firm for 2.5 years, DLA Piper, and it wasn't a good fit for me, so I decided to move on, and I started my own law practice. So I have a chemical engineering background. I knew at some point when I was getting my degree, I wasn't going to practice chemical engineering. I was more interested on the business side of things and more interested, and there was a patent class, believe it or not, at University of Delaware that I took my junior year, and that's how I got exposed to patent law. So long story short, here I am. I've done a lot of litigation in my career. I've done a lot of patent prosecution. The stuff I love to do is really due diligence projects or business deals where IP is involved. So I have a lot of exposure and ideas about sort of the IP world and how it works and how it doesn't work. I was an examiner for 2 years, and I could tell you, based on my experiences back in 1983 to 85, it's a broken system, and it's still a broken system. And it's broken, in my opinion, because there's not a whole lot of consistency from one examiner to the next and within various technology groups at the patent office. So you get all kinds of crazy sort of feedback from different examiners that's not consistent with what we understand the law to be. And they don't necessarily care about the law at the patent office. It's more, as an examiner, you get a bunch of cases and you have to get through them in a certain number of hours. The more senior you are, the more cases you're supposed to review within a certain subset of hours. So it's not a perfect system. I mean, and there are some great examiners and there are some on the other end of the spectrum which are pretty bad. And I'll share some information with you towards the end of the process. But so I think this is a slide deck, part of which I created for another presentation I did last year. But so there's some information in here that I can walk everyone through, just so you get a sense for what's part of the IP world. So by a show of hands, how many people have actually filed a patent application in here? 1, 2? How many people have heard of patents? Okay, good. Hopefully after Steve's class, you at least know what a patent is.
What a relief.
So what are some of the things, just out of curiosity, what are some of the things you'd like to learn today? I'll make sure I try and address some of the issues. If anyone's got any things they want to chat about, I can chat about them, but I can obviously address them while we're talking through the slides. Yep.
I see you have stories on there.
Yeah.
Like learning through examples.
Yep.
What qualifies as something that was a good one, a bad one, or potentially a very controversial one might be a good.
Yeah, so some of my stories are based on actual projects I worked on, due diligence, where we had to sort through a variety of issues that came up with clients that were trying to acquire a company or a licensed technology. And I think in the weeds there, you sort of get a sense for kind of how the patent world takes shape. And I'll talk about some of those as we go. So one of my favorite subjects, due diligence, just because it's a mix of all the things that come up in the patent world. You're looking at patents, you're looking at trademarks possibly, you're looking at copyrights, you're looking at whether there's licensing agreements, for example. So there's all kinds of issues that can come up. And I find that kind of work very interesting because it's like a big exam at the end of the semester. They're trying to get you to sort of check the boxes, figure out what the issues are, and how do you properly address those issues. So a simple summary of due diligence, a process of identifying and collecting information to make an informed business decision. And then here's a whole list of different areas, trade secret protection, in-licensing or out-licensing technology, whether you're going to file a lawsuit, patent ownership is very important sometimes. Not sometimes, all the time, but it can depend on who's going to own it, how they're going to own it, and whether they're going to be able to generate any money from their own IP. So there's all kinds of issues that can come up, and that's generally what I consider to be due diligence. So the most common issues that come up are ownership, who owns it, validity and enforceability. So is the patent valid? You know, in other words, sometimes patents get granted and there's a question that comes up whether they're actually valid. And so this is just a reflection of whether the patent office, and again, I indicated this before, the patent office has limited resources. So there are times when patents get issued notwithstanding prior art that exists out there. Prior art means something that comes before the patent was granted that could be used as prior art. And so sometimes those patents can be invalidated in a court or in a patent office proceeding by identifying prior art that wasn't in front of the examiner that demonstrates that what's being patented was obvious or not novel to one of skill in the art. This is some more of the most common issues, infringement. So infringement is when somebody violates your patent. They basically are practicing a technology that your patent excludes them from practicing. So Steve, will these slides all be available to the class if they want them?
Yeah. Sure.
Okay. Yeah. Yep. So infringement, the most common IP issues. I keep talking about the common issues. Issued patent is presumed valid, may be challenged in U.S. courts or the PTO. Identify third-party patents that may be blocking patents. Do acquired patents cover other third-party infringers? So sometimes in a deal you're acquiring patents, and the question is whether those patents you acquire cover other potential third parties. I think some of this is self-explanatory. If not, let me know. So other patent issues that come up, maintenance fees. So once you get a patent, you have to pay maintenance fees for it to go forward. That's usually 4, 8, and 12 years. You have to make a maintenance payment. In most foreign jurisdictions, there's what they call annuity payments, and that typically comes up yearly. It's just basically the government monetizing your IP to keep it valid and active. Let's see here. So here are what I call the 5 big IP issues: infringement, invalidity, validity studies, freedom to operate. So freedom to operate study, very popular. I use them quite a bit. But when you're representing a client or working against a client, many times you're trying to identify whether your client or the third party has the ability to operate in the universe that they're in. And freedom to operate just means you can find white space where there are no patents that are being infringed. Yes?
So a question related to infringement. Let's suppose that I invent a mousetrap with a small modification that allows me to catch lobsters, for instance.
Okay.
How likely I am to undergo patent infringement of other mousetraps, and how likely I am not?
Actually, a great question. So the question always is, do the claims in the other patent that you're talking about actually cover the lobster trap? And by that I mean, are the claims broad enough? So your claims typically have elements. I'm just going to say A, B, C. So the more elements in a claim, the more limited the claim is, because it's a smaller pool of information and people that potentially could infringe. But if the patent, while it might mention mice as sort of a target, the claim might just say a trap for catching a live animal or something like that, or have limitations in it that don't exclude lobster, for example. So the claim is basically what define the metes and boundaries of your patent. So, you know, it seems to me unlikely that a mousetrap would cover a lobster trap, but, you know, again, claims can be worded in such a way that they're not precluding using it as a lobster trap.
No, my question was more like, if I write claims saying that this new trap, and I don't call it mousetrap,
Yep.
but this new trap is a new innovative lobster trap, but it's kind of a similar technology that already exists for mousetrap. Am I likely to undergo infringement of the previous patents existing on the mousetrap or not?
So it depends on what the claims say. I mean, I always go back to what the claims say. So you have to actually look at the patent that's issued and decide whether that potentially would cover a lobster trap if it's a mouse trap. So you just have to look at what's in front of you. But freedom to operate means you're actually studying. Typically, I'll hire an outside consultant, and they go out and they have all these databases and searches, and they can go out based on technology that you provide to them, you know, chunks of technology defined, and they'll go out and they'll search the universe or whatever scope that you decide to see if there's other patents in that space. And then the objective is once you identify that subset of patents, you start looking at them and the claims in those patents to see whether what your client wants to do or is doing is actually covered by those patents. So if there is a patent out there that covers what your client is doing because it's a broader patent, then you don't have freedom to operate, which typically would mean you either don't proceed or you try and find and get a license from that third party that would have a blocking patent for you. And sometimes it's not always that straightforward. So you have to, you know, this is sort of a, freedom to operate is a de-risking process. It's never 100% certain. It depends on how much money you're willing to spend for a search, and they can range from $1,000 to $10,000, depending on the groups that you hire and depending on the importance of what you're looking for. So it's really a de-risking measure, but I always like to say you're better off knowing more, not less, when you're looking at patents and potential infringement issues. Patentability is probably just what it sounds like, is you can do a patentability study to find whether there's art that might preclude you from pursuing the patent that you want to pursue, or it might give you ideas how to write a claim that gets around the prior art that's already out there. And there's issues that come up, you've probably heard about novelty and obviousness. So that's what a patentability study does. And valuations are really sort of trying to figure out the value of your technology. A little bit more complicated, a lot more issues that come up there. Sometimes you can look at the market and figure out generally what a valuation would be for your technology. Not quite as easy as that sometimes, but nonetheless. So this is attorney-client privilege. You guys have probably all heard from Steve that once you sign an engagement letter with a client, what's automatically created is the attorney-client privilege, which is sacrosanct. It's stronger than an NDA, any NDA there is, because us lawyers are obligated under codes of ethics, et cetera, not to share information. So sometimes you get pushback. A client wants an NDA, and I basically refuse to do it. I just say, look, I have more strict obligations on myself than an NDA would put on you. An NDA is a contract. I'm bound by law to not share privileged information. So, and the privilege is owned by the client, and only the client can waive it. So we help create it, and if you want to waive it, you're perfectly welcome to, but we recommend that you don't do that because it provides a lot of security for you for lots of reasons I won't get into. Anyway, attorney-client privilege. Okay, what happened there? Okay, that was not a good thing. Oh, we went down to case studies already. Okay, we talked about those. Infringement, privilege, other privilege issues that you can. Okay. So, as promised, some case studies. So, I represented a large foreign company. They were looking to acquire a technology. It was dry powder insulin technology. And I think we had a team of like maybe 16, 17 people looking at this. There were a lot of patents involved. We did a lot of our own searching. And what we ultimately found out was that all of, let me back up a little bit. So in many scenarios, the types of claims you get can be very important. There's composition of matter claims that cover products. There's method claims that cover methods. And then there's all other kinds of claims that, you know, a method of using or a method of treatment. So we consider composition of matter claims or product claims the most important because they actually cover the actual product. In this case, it was a composition. So it was a composition of matter claims. What we found in our due diligence was we found some art that was actually, and this is the best art there is, your own prior art is typically the best prior art against you for moving forward. So if you create something one day, you get a patent on it, and then you go and you try and modify that technology with some updates, typically your very own patent, if it's prior art against you, will be used in a rejection because it's obviously reflective of what you've already done. So it's easier to get a rejection in that way. But in any event, so we found, I think, some literature, some articles, as well as some IP that was actually owned by this client. And they didn't disclose it in the patent office from what we could tell. And we ended up blowing up the composition of matter claims and the method of treatment claims, which typically for a lot of deals like this would be the end of the process. But what they also had was a device that was used for delivering this dry powder insulin deep into the lungs. And it was a really clever device. And we met with the engineering team for like a day. They walked us all through it, how they got it deep into the lungs, the particulates that were in there. What they had was a patent portfolio that covered about 103 embodiments of this device. And embodiments just mean different pieces of it or embodiments, different looks, different feels, different ways to combine it. And it was an active portfolio, meaning it was alive. It wasn't patented. There was still ability to file continuation applications, et cetera, et cetera. And so we spent some time looking at it and realized that, and there's another piece here, there was a regulatory piece that was involved because it was a drug. We were in contact with regulatory counsel, and we were talking about timing. And one of the issues that came up was, how much leeway would we have between a third party coming in to try and do what we're doing and where we're at. We calculated we had about a 7-year runway in order to be okay. But what was interesting here was because there were so many different embodiments and it was an open portfolio, we basically determined that we could write claims from this portfolio because it covered so many different embodiments that if somebody tried to come on the market, we could actually write a claim that actually covered what this third party was trying to do. And this is all perfectly legal. So if you have an open portfolio and you have sufficient information in the patent, you can actually write claims that cover your competitors, believe it or not.
Please explain what an open portfolio is, because I haven't gone into that.
Yeah, so you file a patent application, it gets granted, it's patented. That's sort of the closed portfolio, right? It gets granted. But before it gets granted, you can file what's called a continuation application to keep the application or pieces of it alive, because you might have other embodiments in your application. Sometimes you're forced to file or get a narrow claim just so you get something patented for lots of reasons, funding, there's all kinds of reasons to do that, because it slows down the process sometimes if you're trying to draw it out. But what you do is you file a continuation before the patent's granted, and then you can pursue another set of claims, and you can keep doing that as long as you want. And the patent has a 20-year lifetime from filing to basically termination. So at some point you'll run out of runway to file new applications. So in this case, it was an open application, meaning that the patent was still pending. We already had, I think there was a grant already, but we had the ability to file whenever we wanted off of this patent. So that gave us sort of a little bit of strength in this technology, and we decided, based on the regulatory pathway, which would likely be a 7-year runway, just that was a safety net. But in addition, if we felt we were ever being attacked by a third party, or they were trying to copy what we were doing, we had the ability to write a claim that targeted them specifically, meaning we could figure out what they were doing and write a claim that was very simple, clean, and right on top of them, meaning that they could not practice the technology without infringing our patent.
Because there was a regulatory component that you needed to get approval, you were going to take advantage of the fact that it takes time to get that regulatory approval in order to keep the portfolio open. And while the portfolio is open, you would then file different claims in order to exclude or prohibit others from using the technology.
Yeah, a little bit of everything. But the regulatory pathway just means if a third party came in on day one, we predicted it would take 7 years before they ever got approved. So we actually had the bandwidth to say, and for our client, that was all they cared about. They had enough runway, 7 years, to sort of meet their financial goal if they were going to acquire this technology, right? It just allowed them to say, we can make the money back or that we need to make in order to do this. On top of that, we had all these other weapons that we could use. And because of the device piece, we were able to sort of green light the project and told them it was okay to go forward. Long story short, they ultimately didn't go forward because there were some studies that showed there were some potential cancer risks with deep powder insulation. But that's sort of a side to it. But anyway, from our perspective, we sort of achieved our goal of saying you're able to go forward, and we think there's some strength here based on the regulatory pathway as well as the ability to target third parties if you needed to. So these are the kind of projects that I think are a blast because they cover so many different issues. Okay, this is more of the same. That's more. So I'm actually chief legal officer of this case study. This company's name is a REIT. I'm their chief legal officer. Neurodegenerative diseases. And, you know, when I first sort of got retained by these guys, we spent some time looking at their technology and what was out there. We found a couple patents, and it involves a protein. And we found some patents in Hong Kong and Finland that actually covered our technology generally. I mean, we had a pretty significant application with lots of different issues in it, but one of the things that we were looking at was composition of matter, the protein in particular. So problem and solution blocking patents, we found some applications. Some of these were pending. We reviewed claims, considered infringement issues. And in the regulatory world, there's a neat little patent safe harbor which basically says if you're in the regulatory world and you're developing data to file an IND, which is an investigational new drug application, you can actually practice patented technology free, meaning free of any allegations of infringement. Now, and you can do that all the way through the FDA process. As long as you're collecting data for purposes of getting FDA approval, you're allowed, that's why it's called a safe harbor provision, you're allowed to pursue this. And so that was one of the other workarounds. It's not really clear up here, but I sort of advised the client, look, we could try and blow some of these things up, but right now we should focus on doing what we need to do in the lab, develop the data. And we're not going to have any allegations of infringement because we're protected by our patent this is our patent statute that gives us a safe harbor for regulatory applications. So anyway, questions at this point? Yeah.
Is the safe harbor only for the FDA or is it any regulatory board?
It's, so if you, the statute is in, it's 271E1 in our patent statute, and you're going to have to look under the infringement provisions. But it talks about regulatory generally, and that's a great question that you ask. Generally, it sounds to me like it would apply to other regulatory processes. Where it really comes up, and it comes up a ton in life sciences because of all the issues that come up, that's where it gets used the most.
Okay.
So if you can't find it, let me know. I'll give you an exact site at some point.
Okay.
All right? Yeah, my pleasure. Hi.
Could you talk about some of the negotiation strategies that you would recommend to a startup who finds themselves in a situation where there's the risk of overlapping patents?
Yeah, so negotiations are fun. They can be, depending on which side of the boat you're on. And I'm actually reading a great book right now. Funny you asked that question. I highly recommend it, but it's called Negotiating the Impossible. And I got it at a conference recently, and there's a lot of just great stories in there. But the bottom line is there's always going to be somebody who's got a little bit of leverage on you. And so the question a lot of times is how do you neutralize the leverage? How do you make the process more fair? And the process just means how you're going to negotiate, right? Is it going to be back and forth? Is one guy going to start at 50 and you're going to go to 25? Or how's that going to work? And so there's always... You have to sort of look at the other side and see what you think their perspective is, right? So it's not just you against them, it's sort of this process. Like, what's fair value? Like, they might be coming at you and saying, and so this happens a lot. Like, big companies will go after little companies and just, it's the David and Goliath story, right? And it's not always fair, but there's a lot of pressure to either get out of the market or, we're going to come after you or take a license. And here's the royalties. So sometimes there's situations where you don't have a whole lot of negotiating leverage, but if you can find something in the third party that you're negotiating with that might sort of help balance or diminish the leverage they have on you, like some other piece that maybe they're not aware of that they would benefit if they were able to work with you. Like maybe you have a technology that could benefit them. Or there's some other aspect of it that they're not aware of that could benefit them. So there's a way to sort of get out of the, oh my God, I'm going to get beaten up here. There's a way to sort of negotiate through the challenges and figure out what's more fair. And at the end of the day, I can't predict, but I've seen a lot of these David and Goliath wars where they just, maybe they'll swoop in and acquire you. I mean, that's also a good, possibility if the valuation is right. So you might have in your own mind, and so doing your homework is, I guess, where I'm going with all this. Like if you're going to be acquired, you should know what you're worth, in the world that you're operating in. What is the true value of your technology? How big is it? And then once you can figure that out and you're confident about it, you can sort of go back to these guys and say, look, I'm happy to be acquired, but it's going to be X. and here's all the data and the proof and everything that you need to see. So I think, feeling as though you're under a rock sometimes can be resolved by you thinking a little bit outside the box and sort of looking at the bigger picture and trying to figure out, who really has the leverage here. And maybe they want to acquire you because you got great technology. And if that's true, you got them by what. So I mean, they're no longer Goliath. You might be Goliath at that point. So I would definitely pick up that book. I'll take it back before I leave, but read it. There's got a lot of stories in there about the process, about all kinds of stuff, the history of negotiations in countries where there's all kinds of conflicts. So it covers a lot of different kinds of subjects, but I think there's pieces in there that are very beneficial for everybody. So worth the read.
What you're really describing here, and I'm coming at this from the standpoint of the entrepreneur, the inventor,
Yeah.
somebody at MIT with a great idea
Yep.
and very little money.
Yep.
And what you're describing is really a partnership between the owner of the intellectual property and their attorney. Can you describe the roles in that partnership? And how does an inventor afford and how can they, in a way, how can they not afford to enter into this sort of partnership in such a way that it works for both parties?
You're talking about the attorney-client privilege, that partnership?
Well, I'm talking about how if you're at MIT and you've invented a better mousetrap,
Yeah.
you don't know how to prosecute that necessarily.
Yeah.
You don't know if you can practice it. You don't know what freedom to operate is. You don't know. There's a lot of things you don't know that you need a specialist like yourself. So we're really talking about a partnership between the inventor and the attorney. Can you describe that partnership in a little more detail, and how is it established, and how do you afford that? Especially if you're full of ideas, but your bank account is empty.
Yeah, great question. And I'll tell you this, like I work with a lot of companies right now that I only get paid if I successfully close a deal. And the deal potentials for some of these are huge. I just agreed to work with another former client, not a former client, a current client, but he and I are going to form a partnership, and he's got some great life science delivery technology that he thinks we can market to the life science community and beyond. And so I said, look, I don't have any money that I can bring to the table to partner with you, but I'm willing to offer my services free, and I'll be the lead on negotiations anytime we get into some of these deals. So that sort of answers the question. For folks in college and stuff, yeah, I mean, money's tight. You can file a provisional application for $200, so it's dirt cheap to file a provisional. When you start looking at filing a formal application a year after that filing date, it gets a little bit more expensive, but there are small entity fees, there's micro fees where you have to demonstrate that you're basically poor to pursue it. But I think what Steve is getting at, and the point I should address, is you really want to be working with somebody that sort of knows their way around, right? You have, whether it's just picking up the phone from time to time and saying, hey, can I talk through some issues with you? I got this, how do I write an application? There's forms that sort of basically summarize the format of a patent application, a preferred format. Claim drafting is usually the trickiest part of a patent application because you're trying to cover the universe, but you're trying to cover it in a meaningful way so it's not so broad that you're just going to get rejected right away. Claim application writing and claim drafting is a real expertise. And I'll be honest with you guys, I'm not that much of an expert in that space because I don't love writing patent applications because it takes a lot of time. It's a lot of focus on detail. But I know a great application when I read one. And so I think to the extent you have a mentor or somebody that's done patent work, it's worth reaching out to them and just let them know up front, look, I don't have a ton of money, so, can we work on some other concept, whether it's, I'll do this for you, you do this for me, sort of bartering, basically. I think that's a fair way to say it. And, I'm willing to talk to people about stuff when it comes up. I mean, my contact information's on one of these slides. Feel free to pick up a phone and chat if you have questions. I'm not sure that I'm going to be willing to take on a bunch of people just because I got my own stuff going on. I don't want to make promises I can't. But, if there's a great opportunity and I do my due diligence on it, I'm likely to want to maybe get involved in some way. So that's the other piece of the story, which is I'll never say no to everyone. I'll just let you know that when things pop up and there's an opportunity where I think I can add value and really, some real skill to it, then I'm happy to maybe think about a process for getting involved. So I don't know whether I've addressed.
Yeah, I mean, this, you can't be expected to know everything if you're the inventor.
Right.
You really have to rely on others' expertise. And
So
think
I would say most inventors know nothing about the patent system. I mean, unless they've been doing it for 30 years and they've been through the process. But to be fair, there's a lot of smart people out there that think they know everything. And when you get into the patent world, it's a completely different domain. And I think sometimes people can get ahead of themselves about, what their patent is, what it covers, without realizing all the nuances of that stuff. So
I think the smarter you are, the more you realize you don't know.
well, hopefully.
My point was that I think inventors have to understand that the invention is only one part of this, of bringing intellectual property to market. There's other expertise that is absolutely essential. And they need to understand that if it means cutting a deal for a percentage, they should be happy to do that because their invention goes nowhere without the skill and expertise of people that can fund it, prosecute the patent,
Yep.
Commercialize it, bring it to market, in the same way that you wouldn't mind giving a piece of the action to a manufacturer in Seoul, Korea, who's going to produce your widget. You need to understand that in many cases, an attorney and a banker are as important as the inventor in this process. Would you agree with that?
100%, and it sort of builds off of what we were talking about over here. I think you might create a great patent, you might have a great patent that covers a great technology, but how are you going to monetize it? Like, what are you going to do? Who are you going to talk to? How are you going to reach out to parties? Can you figure out the valuation of it? Like, so when you go into a negotiation, you have a real sense of what you're worth. If you don't, then you're leaving money on the table, in my opinion, because somebody else is going to jump in and try and take away some of that
They're all
value.
experts in backward and forward citations. So they
Yeah.
know the value of
Yeah.
their stuff.
Good luck. Good luck.
Everybody nodding?
So what I can tell you about valuation is a lot of times it's guesswork informed by some fence posts. And typically it's a range. It's never like, here's the valuation. It's kind of like, here are the valuations. And there's, both sides of the spectrum. But Steve's point is a great one, which is you might have a great idea and you might get a great patent, but if you want to monetize it and do something with it, you're going to have to figure out what that path looks like. Are you going to play a role? You're going to exclusively license your technology to a third party and then just get royalties? Sometimes on these deals, you can ask for an upfront payment, and sometimes these upfront payments can be gigantic depending on the value proposition. So with a backstream royalty. So you could get a $100 million upfront payment, and then get royalties on anything that's produced over time. So there's all kinds of, be as dynamic as you can in your thinking about the possibilities of your technology. That's probably the ultimate takeaway.
Got a question back here.
Yeah.
So
Yeah.
you were an examiner, and you mentioned that you can read an application or patent and say it's great. What are the traits that make a great application or patent?
One that's thorough in the sense that there's supporting data in there. So one of the weaknesses in lots of patents is they have a few data points, not many. And so, but you're trying to claim the universe, and the patent office these days is like, not going to happen. They'll let you get a patent maybe on the 3 data points that you have, but nothing beyond that. And so if you have 1,000 data points, you have a much greater chance of getting much greater protection. So data is important. Don't disregard it. Think about it as the lifeblood, in my opinion, of most patents. So if I'm looking at chemicals or life sciences, like even in with mechanical devices or anything like that, even computers, et cetera, again, data. If you can validate in your patent with data that this technology works, here's what it does, here's what it achieves, you have a much greater chance of having a patent that's strong, covers everything that you would expect that it would cover. It gives you a lot of strength in negotiations if you get it. And it makes it more difficult for third parties to sort of come in and kind of undermine you. So, so clarity, are you looking at weight percents? I've had a client recently, and I didn't draft the application. They just said 50%. They didn't have mole percent. They didn't have weight percent. They had nothing in there. And I worked my butt off to prove to the examiner that it was clearly weight percent, because it was ink technology. And if you look up ink technology, almost all that stuff is done in weight percents. I had a declaration from a third party. I had 2 declarations from a third party. Examiner said, not doing it. Now, if I decided to appeal that and go farther, I might have overruled the examiner, but the client was like, I'm not spending any more money. So in the beginning, the better the application, the easier it is for you going forward, with more details, being more thorough. And so I think some people get worried about sharing too much information, but if the information is relevant to the application you're filing, meaning you're not talking about a completely different technology in the application, you're focused on what you're doing, the more data you have that supports what you're doing, the better off you're going to be in the long haul. Because you might find for one set of data, there's prior art, and for the other set of data, there's none, and that might be the route you ultimately get. But you might get claims that are sufficiently broad that you're covering what you need to have covered.
When we talk about data, you're talking about data that tends to show provable utility.
Yeah, all the above. Like
it does what?
when your claim says, a chemical for solving XYZ, you have data in there that shows that it solves XYZ, right? You've actually run the test, basically, is what I'm saying. So how much time do we have? 10 more minutes, okay. So one more case study. 5?
5, yeah.
Oh, 5, okay.
That's 5 to...
So this is just another study. I'll let you read it. I want to go down sort of to I put it in some other patent slides here that I think you'll find useful. Yeah, you either hate them or love them, all right?
There's that word again.
Yeah, depends on the day. And there's lots of days I hate them, and there's some day. So I've had some great examiners, and they actually just, you can call them up, and they'll work with you. You say, if you do this, this, and this, I'll grant your claims. And there's some that they're like lemons that have been squeezed 1,000 times, and they got nothing left in them. It's ridiculous. So I've given up on the process. I mean, I haven't given up, but I still do some prosecution. But for me, I just find a lot of it to be a total waste of my time, just because I feel like you have a good conversation with an examiner, and then you get more crap. It's like they're passive. Some of them are very passive aggressive. I worked there for 2 years. Let me tell you, there's all kinds of strange people at the patent office, but some really good people too, and they tend to get promoted out of the examination core, and they go up and work on the board of patent appeals or wherever. So I think the good people, there are good people there, don't get me wrong, but I think the examination core tends to be very iffy. And the other thing that you'll find in the patent office, depending on the art unit that you're going to be filing into, meaning the group or the technology group, there are delays some years of up to 4 years till you get actually your first office action from the patent office. 4 years. You know, we've all aged by 4 years before you get any meaningful. So there are some things that we can do to advance that, and I'm gonna talk about them. So, yeah, I got the old guard, I got the newbies, excellent to worthless, luck of the draw, and that's very true. Luck of the draw. You can't pick an examiner; they basically get assigned to you. Okay, it's like poker. Get to know them through interviews. So this is one way to sort of try to form a relationship. Don't hesitate to pick up the phone. Say, hey, I want to talk about this case. Talk about these claims, give me some of your thoughts. Some of them will cooperate or be willing to talk to you. Some might be, well, let me see the claims first and then we'll talk. And sometimes I'll send draft claims into the examiner before I send in anything formal. I'll say, can you take a look at these and just give me a sense for whether you think I'm going in the right space? Save yourself some time and heartache. We all have a tendency to think the claims we're drafting are perfect and I'm not aware of any problems. You send them to the examiner, like ding, 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 and here are the things. Now, they may be wrong on some of them and right on some, but if you do this in advance and you get some sense that they're going your way, then I think you're making progress and you're saving time and energy. Yeah.
Yeah, and so I'm just trying to picture what they're actually doing. So, because it sounds terrible.
So they all have laptops now. When I was there, we would go into a room with drawers in it, and you pull out old patents with dust mites on them, and you know it's all computerized now. They do everything electronically. So.
They're like literally pulling up other patents.
Yep.
Going,
yep. They're searching in the field. They're looking. They're comparing. They're just trying to find any reference that they can combine that will basically support a rejection.
Who behooves them to reject you because of the amount of due diligence they have to do?
It used to be a joke. It's the rejection office, not the patent office. That was sort of the thing But again, there are some examiners who they see great technology and they appreciate it and they're like, okay, let's move this forward. And there are some who I think are they've seen so much of the same technology that they're not really willing to work too hard to find the allowable piece in there. So, okay, so here's some, I think, helpful information. And you can Google these and more. If you Google stats of examiners, like this one up here is just, you can pull up how the percentage of patent cases that these examiners allow. The one I'm working with right now is like 39% of his cases get allowed, right? I think we're making progress with him, but so, and the other one, and then here's another site, the most difficult, yeah, whoops, sorry. Yeah, so here's another site, the easiest, the most difficult patent examiners, allowance rate and actions per disposal. You'll find 100 providers that are analyzing the data coming out of the patent office. So there's no shortage of data. If you do research on the people that you're working with at the patent office, that you'll find it. And here's one that's just basically and this is USPTO grant rates, which is overall the whole patent system, and it's like 69%, believe it or not. But when you start looking at different art units where the technology goes, I mean, the allowance rates are disparate. I mean, they're all over the place. And some technology centers are really low, others are higher. I don't know whether it's some art units have less stress because they don't get as many patent applications, so they have more fun with it. I don't know, but I haven't figured out all the nuances. So if you want to expedite your filing, so once you get out of the provisional stage and you're filing a utility, track one's the way to go. So for a large entity, 4,000, this is a lot of money, 2,000 for a small and 1,000 for a micro. You can only file 4 independent claims, a total of 30. So here's the difference. Your first action comes in 3.9 months versus an average of 18.4 months. So if you have a technology that you really want to get a patent granted on quicker, that's the way to go. The limitations, I don't have all of them. Here's some, there's no extensions of time, so you get a 3-month period. And if you past that 3-month period, have to file an extension of time, you're out of track 1. So the process is set up so that, which?
Can you repeat the extension that you're
Oh, so in most examinations, you get an allotted amount of time, and you can take an extension for a fee. In track 1, you cannot take any extensions. So the process is set up so that you focus narrowly on the technology, you work with the examiner to try to get your patent allowed within 12 months. That's generally the targeted goal. So it's a very good process if you have the money, the wherewithal. If you're a micro entity, it's still $1,000, which is a lot of money in my book. So accelerated examination is another examination, but you see the fees are a lot cheaper. This is for like where somebody's infringing your patent, you can file a petition. Somebody's older, you can file a petition to get accelerated examination. But you have to do what's called pre-exam searching for documents. So you actually have to do a patent search yourself and submit it with the patent office. There's other restrictions, as I note, and I provided a link there. And then there's a patent prosecution highway. So if there's a foreign office that you filed in and they have allowed claims, you can go into this patent prosecution highway, which expedites typically all the other foreign filings. And generally the offices try to coordinate in the patent prosecution highway. So you're likely to see more cases get allowed quicker if you enter that system. Here, no additional fees, no claim limits. So again, first action, you're still looking at, a year, but it's better than, and that's an average of 18.4. Like I said, there are some art units where you might be waiting for 4 years. So that's it. I squeezed a lot into a little bit of time. So if anyone has any questions, honestly, my contact information is somewhere. It's on the first slide, I think. Feel free to email me, and I'm happy to get on the phone call, talk you through whatever tightrope you're on, and give you some insights and guidance.
Thanks, Mike.
My pleasure.
Thank you.
Yep.